Welcome back. You all have noticed that we're being videotaped, and we're being videotaped because USA Hockey has asked us to do this. You might be interested to know that once SafeSport was mandated by the USOC to all of the national governing bodies for youth sports that they have participating under their banner, so to speak, of which USA Hockey is one. USA Hockey has really been on the forefront of this program. We were the first one to launch our SafeSport program completely, and the USOC uses our program as the blueprint for other people. Steve Lang, our fearless leader, El Jefe, was responsible in many instances for helping develop the program and has been involved in some of the more serious investigations throughout the country. So I think that's really kind of a cool thing to know. We're really on the cutting edge of this stuff, and we in California, I think, are the first affiliate to do a program like this. At least we're getting videotaped for that. Anyway, we're going to talk about investigating claims and recognizing problems associated with SafeSport. But let me give you some statistics first. Last year, we in California had 31 reports of SafeSport violations, of which 15 resulted in full investigations, 3 police reports, and 3 hearings. Actually, it's 4 police reports. There was an incident where we had to get the police involved 4 times. So it works, and we've been doing it in California. All but 3 of those instances, and I don't believe any police reports were necessary, occurred. Well, we didn't have any up here. All but 3 of the SafeSport investigated matters was in Southern California. Now that means either we're doing something really good, or some of these things aren't getting reported and dealt with. And so that's kind of what I want to touch on right now. So you received a complaint, what do? If you're Bart Simpson's dad, you say doe. But this is always a stressful event when one of these things happen because we have to act. The goals of SafeSport are to investigate, to report, to investigate, and to have a hearing if necessary that will render safety for our members. This may involve putting discipline in place. And we're going to talk about this during this block. So here are the goals of the handling a SafeSport complaint. First and foremost is to stop whatever abuse is occurring. Obviously, that's a big goal. And it's to stop it from reoccurring as well. Third is to protect the victim. If a matter rises to the level of a SafeSport complaint, there's probably a victim out there. It's also to sanction the abuser if that's necessary. And to create customer satisfaction. How many of you folks realize that the people that pay organizations large amounts of money for their kids to play ice hockey are actually customers? That's one guy back there. That's a hard concept to understand because it's almost an adversarial situation, but these people are our customers. Now, it's a little bit different in the sense that we don't have to offer them a free meal and all that sort of thing because they have to follow the rules that are established. But we should start treating them more like customers and dealing with customer satisfaction. Obviously, investigating complaints limits the liability of our organization if that's necessary, and it eliminates bad publicity if at all possible. Finally, it preserves the integrity of SafeSport and our organization, and it's always used as a learning tool. As a lawyer, I've often said that there's only one redeeming quality to being a lawyer, and that's that it at least provides me with the opportunity to wake up every morning and see something I've never freaking seen before in my life. SafeSport is pushing that envelope. And when we get to some of the hypotheticals, you're going to be in awe of, did this really happen? And every one of them did. So a report versus a complaint. This slide is meant to identify how you as somebody with boots on the ground might determine that there's been a SafeSport complaint. First is a personal complaint. You might be sitting up in Stanley's having a cup of coffee and somebody comes up and talks to you, and then all of a sudden, oh, by the way, Coach X has been throwing water bottles in the locker room and the Mite players in there are scared. Complaints on the behalf of another. Somebody might come up to you, or somebody might say, so-and-so is afraid to talk, but this is going on. Or somebody might say something they saw. I saw a coach on the ice hitting kids with a stick and shooting pucks at squirt players as hard as he could. And then there's also the report of an observation. Somebody said that they saw this. Each one of these instances are sufficient to start a SafeSport investigation, which needs to be reported in some fashion. That's what I'm concerned may not be happening. There is a statistical side of what we're doing. Every month or every quarter or so, I have receive an email from Joyce here that says, I want your SafeSport report. I keep statistics, and it's a spreadsheet that talks about who did what to who and with which, how it was resolved, and what's pending. And 4 or 5 emails later from Joyce, I usually get around to sending her my spreadsheet. But we need to know when these events occur. So anytime somebody makes a complaint that leans into a SafeSport issue, you need to open an investigation. And I need to emphasize that because it's a hard concept to get across. Sometimes these investigations last minutes, sometimes they last months. But we need to open an investigation and report to me what's happened, or to Laura. So the first question you have to ask yourself is, who conducts an investigation? I would like to see these investigations being done locally as much as possible. However, there's some things you have to consider. If you're the local organization, say the Blackhawks or the Santa Rosa Flyers or the Junior Sharks, as long as there's no conflict of interest and no overarching or compelling issue involved, you're absolutely free to, and I encourage you to investigate these SafeSport complaints. Keep me and Laura posted. Let us know what happens. We're available to help you if you need help in doing that, but we'd like to see you start investigating these complaints. However, if a complaint involves an act or omission from someone in the association, this case it would be the program, then the program is probably not appropriate to do the investigation. Maybe it ought to be done by somebody at NorCal or in the South SCAHA. Are there concerns concerning impartiality of the association or of the program? If there are, we need to avoid even the appearance of impropriety when we're doing these investigations. That means that if that issue arises or it's a concern of yours, kick it upstairs. Are there accusations of a crime? In every instance where there is criminal conduct that's being alleged, particularly when it involves abuse, sexual or physical, of a minor, you need to get the cops involved. It's mandatory in the case of minors. It's probably a good idea if you have 2 parents that are fighting. And then, does the issue require affiliate involvement? How would you know that? How would any of us know that? And that's not a rhetorical question. That's a real question. And that's why I like to get involved, and Steve and I work together on these all the time, and sometimes we all 3 work together to decide how this investigation is going to be done and who's going to do it. There are instances where it will be up to USA Hockey to conduct an investigation. I can see that happening, and I'm so glad to learn that the USOC is setting up a separate entity to deal with nothing but sexual claims. anybody who is in the business of asking tough questions, of which I am, knows that those are the hardest questions to ask. And it's a very uncomfortable and unfriendly situation. I do it, but I don't like to do it, and I'm glad to hear that there's an organization that's going to be doing that. So these are the steps of an investigation that everyone should follow. And I know there's some folks in here, but how many people in here have interviewed folks or conducted an investigation on a third-party basis? Okay, there's a few, as I would expect, and some of us in here do this as a living, but the first thing you have to do is contact the complainant. Find out what's going on. And this is maybe one of the more important contacts you will have because it's usually emotion-driven. There's either anger or remorse or something involved from whoever makes the complaint. Sometimes the complainant is a third-party complainant. And by the way, if somebody makes a complaint and they say, I want to make this anonymously, they're entitled to do that. Many times, though, I have to tell people that say that they don't want their name being kicked around, that may shorten the investigation because without coming out of the weeds and identifying who you are and dealing with this, we may not be able to solve the problem. Once you find out from the complainant what's happened, you have to sit down and analyze, okay, what am I dealing with here? Am I dealing with emotional abuse? Am I dealing with hazing or threats? Am I dealing with what it is? So that's what you do next. Next thing you do is contact witnesses. And this is a rather important aspect of your investigation because these people are creating the evidence that you might have to use if there's a disciplinary process. I always ask witnesses to write out what it is that they want to say about this event. Some witnesses are reluctant to do it. You can't make people do something that they don't want to do in this context. But most people will. Children. If children are witnesses, you should do whatever you can to get them to try to put it in writing. Now, the surprise might be mom and dad write what the kid says. But at the same time, you should try to get your statements in writing if at all possible. If you do an interview, you need to take copious notes and prepare a memo on that later on. And again, common sense applies here. If there is a real serious allegation pending, you may want to be a little more precise than if it's something that's not that serious. Because at the end of the day, we may have to use these in the context of a disciplinary hearing. Once you've done that, you have to sit back and evaluate the process and evaluate what you have. And you do that before you contact the accused person. Is that the coach? Is it another player? Is it a parent who is out of control, et cetera, et cetera? Sometimes this may have already been eclipsed because there will be a police investigation. I'm not kidding. It happens sometimes. The association being the Sharks, yes, it may be. But I can see a situation where a team manager might have an issue where, and you know what? Save it until we go through some of the hypotheticals because I've got a couple that are addressing what you just said. There are times where it's appropriate for you guys to do that. And it may be a situation, because I said earlier, when somebody makes a SafeSport complaint, you have to do an investigation. If the SafeSport investigation takes 5 minutes because it's a misunderstanding, it still needs to be documented and resolved, but that's something that might be appropriate for you to do. You sort of have to go through this process about who to conduct investigation. Not to give things away, but let's say somebody observes a coach doing things on the ice that are perfectly appropriate. He's speaking loudly. It's hard to hear out there. He's not swearing. He's moving people around physically. He's pushing kids with his stick to put them in the right position and all of that sort of thing. You and I and everyone in this room who's observed the practice knows that's perfectly appropriate. There's at a time when, but somebody who comes into this not knowing that may think it's abusive. There's a different way to deal with that than when a coach is abusive. But you still have to report it as a SafeSport complaint. If that person says, well, I think it's a SafeSport violation, I want something done about it. I know. There are people, though, that they need that clarity, and those are the kind of folks that we need to have a very transparent record that we dealt with them. When you contact the accused person, it's very important that you let them know immediately what it is that they're being accused of, dispassionately. Coach, this is what you're being accused of. If the person who makes the accusation has not made their position in all of this anonymous, you can tell the coach who made the complaint. And you want to find out from that coach exactly what happened. You want to find out his or her story. But it's really important to let them know. And if you have witness statements at that time, it's perfectly appropriate to share those with him and give them to him, because you're going to have to if there's a disciplinary process anyway. But this helps resolve these kind of issues. This is a flow chart that sort of talks about what I'm talking about here. As an investigator or somebody who's having to deal with this in your capacity as a team manager or even a coach, a program administrator, NorCal SafeSport coordinator, whatever, this is the process you need to follow. What are the urgencies involved here? Is there a hospital we need to contact? Are there people in immediate danger? Is this something we might have to deal with a summary suspension, which we'll talk about later on? Is there a police issue involved? If there is a police issue involved, call them immediately. You will never get in trouble for making a call to the police unless you do it with a black and maligned heart, which we don't have. Obtain a preliminary witness list as soon as possible. You need to know who has to be contacted. And this is even if you're not going to do the investigation. Sometimes the team managers are the best people involved in terms of sorting out who it is we need to talk to and what it is we need to find out from them. At some point, you have to assess the complainant's wishes. What is it that you really want? And I'll tell you a little war story, because this actually happened recently with the Jamie Campbell down south. The timing of this complaint says a lot. It was after the season was over, after their playoff and championship positions had been secured, that a complaint was made about a coach. This coach is mean. This coach physically manhandled my kid. He yelled at him. He threw a water bottle at him. All this. Well, when did he do it? Back in September. What do you think the first question I asked him was? Why'd you wait so long? What do you think his answer was? Well, I didn't want anything bad to happen to my kid. It was a very interesting dynamic. He let his kid play on this team for the entire season and into the playoffs, and then came up later and said that his kid was at risk that whole time period. I know. Shake your head and say, what the heck? But that's what he did. Yes, ma'am. How old was the child? I know, but it would seem to me as a dad that I'm more concerned about my child's safety than whether or not he gets to play USHL or NHL or whatever. And so that is a consideration. But to me, you lose big-time points for not approaching a problem and later on raising it as an issue. And my whole point in all this is that we found out about this. We had a conversation with the coach. He was disciplined, albeit on a local level. He didn't go through a process, but his attitude was adjusted appropriately during the season while all this stuff was going on, and Dad was presumptively sitting and fuming about his kid being at risk till the end of the season. At the end of the season, this guy went postal on us. He sent Jamie Campbell 3 emails one morning before 6 a.m., and they were not short. They were long emails railing and ranting about how his child had been abused and how this coach was a pariah, and it got handed off to me, and the first question I asked him was, what do you want? I want that coach banned from hockey forever. I want to know exactly what was done to him, and if there are certain body parts that can be tacked on the entryway to the ice rink, as an example, I would like for that to happen too. That was at least a 3-page email. I'm not kidding, maybe a little bit, but it was that kind of a conversation. When I told him politely that the situation had been handled, the coach had been appropriately handled, and discipline had been, and I didn't tell him about what it was, then I became an abuser in his mind, and then I got it. So I was getting the emails, fortunately it was after 6 a.m., that Jamie was getting before. Ultimately, he shut up and went away. But he created a problem for himself, and this is something that you look at when you do these investigations of when is a complaint made in relationship to when the behavior happens. At some point, you do have to ask the complaining party, what is it that you want? And I would suggest that if the first thing out of the complainant's mouth is, I want my son or daughter to be safe, if that's not what it is, then maybe there's a secondary agenda. That doesn't mean that you disregard the complaint, but you need to note that and move on as you do your investigation. And then the last thing you do is determine who will investigate. If it's a kid, then the coach might investigate. If it's the coach, then the association might investigate. If it's the association, then the affiliate, CAHA, might investigate, and so on. That's kind of the process we go through here. When you analyze allegations, this is a very good sort of dynamic to look at. Are the complaints perceived or specific? I think the coach might be touching Johnny in his secret no-no spot. Well, do you know that for a fact? No, I just think he might be. That's a different level of complaint. Doesn't mean you don't take it seriously, but that's part of the analysis that you go through. Can these allegations be verified? Obviously, if they can, you've got a big problem. If they can't be, you still have a problem. It may not be as big. Are they isolated or chronic? Is there a pattern of practice here? Some SafeSport complaints need patterns of practice, emotional abuse, that sort of thing. If it's an isolated event, it may have a different trigger than if it's a chronic event or going on. And are there additional SafeSport violations? This comes up all the time. You may find out that somebody is physically abusing somebody, and then all of a sudden you have to deal with bullying, threats, harassment. Somebody may be making inappropriate remarks to somebody on racial grounds or ethnic grounds, gender grounds, that sort of thing. So when you analyze allegations, all of these things need to come into play in terms of how you go about doing your investigation, who you talk to first, and what you ultimately report. When you contact witnesses, you have to tell them expressly who you are and what it is you're doing. My name's Lance Burrow. I am the SafeSport coordinator for the state of California. I'm investigating a complaint that so-and-so did this and that to Whoosie Watson. Very clear expression of what it is. You have to express what form of SafeSport or what it's all about in the program and how it works if they're not aware of that. Stress confidentiality. If you don't want me to disclose who you are, I don't have to do it, and I won't do it. Identify the goals, what it is you're trying to accomplish and what will happen at the end of this. And this, of course, depends on what the complaint is. If it's a serious complaint, there may be a serious ramification to it. You should say so if you're doing the investigation up front so that people understand what it is. And then you have to caution about retaliation. And this is always something that concerns me, because retaliation is very difficult sometimes to see and to analyze and to prove. You know, there's the difference between earned ice and I forget the other term, but it's where it's equal ice and earned ice. If you're playing might be hockey, if there is such a thing, everybody better be getting an equal touch of the puck and an equal amount of time on the ice. There should be no reason for anything else to happen. But if you are a Tier 3 team, there's earned ice. Some players, better players than others, will get more ice time, will get to play on the power play and all that sort of stuff. And that's the area where somebody could come in and say, I'm being retaliated against because little Johnny isn't on the power play. Little Johnny's a goalie. He's not supposed to be on the power play, Mom. But these are what you have to look out for. It's interesting, I think I mentioned the travel policy and the issue with the coach down south that had a different one than USA Hockey was. One of the things that the mom was concerned about, and she wouldn't even tell me her name when we first started having our discussion, much less who the program was or what the coach's name was. And also, I had to play 20 questions, and I finally figured it out. She was very concerned that her first-year Tier 2 Bantam player was going to get rained upon because she made this legitimate SafeSport complaint. And, you know, that's a work in progress. We're watching that right now because I am concerned, given what I understand about the coach and his attitudes towards SafeSport. But hopefully that attitude has been adjusted, and we'll find out. Evaluating your work product. Some of the questions you ask. What is the history behind the accusation? Again, use written statements. And are there denials? Does somebody deny an allegation? Sometimes, you know, people that have complaints made against them are pretty smart. And they won't say they did it, but they won't deny it either. So you've got to listen for these things. Using written statements also eliminates the ability for somebody to deny. If they write in a statement, yeah, I did that, and then later on they deny it, you just show them what they wrote. What's going on here? It reduces misunderstandings. If you can show somebody what somebody else said, they can't say, I didn't understand that. It can be compared to additional statements. At some point when you do an investigation, you sit down and you put all the statements together to see how they line up and what they do. Mike Severi and I do this. We call it trial prep. But in this case, this would be how are we going to reach the outcome in this? You can also analyze these statements for content. Some people are saying the light's on, some people are saying the light's off, and some people are saying it goes on and off, as an example. And if everybody's saying the light's on, the light's probably on. And that's how you go through this evaluation process. Also, using written statements saves time. You don't have to recall what you said. You don't have to write it again in a memo, and it just saves time in getting this evaluative process done. Again, I've kind of gone over this. Contact the accused when you tell them who you are and why you're calling. Explain the accusation. Note if there are any admissions, or if there's a complaint that's being made against somebody else. This is a tactic that some people use, and sometimes it's valid and sometimes it's not. But if somebody makes an admission to you and they haven't done it in writing, write it down yourself, because you can use that to at least refresh your recollection later on. If somebody's confused, note that. I told the coach that he was accused of touching Johnny in his secret no-no spot, and he was confused. He didn't know what a secret no-no spot was. That might be important later on. Note denials. Somebody specifically denies an allegation, you need to note that. And then ask them or note what they're willing to do. Many times people say, yeah, I overreacted. I did throw the water bottle. It's a long story. I'm sorry. I'm willing to go and do this or do that, and you note that, because that may be very important in terms of how this SafeSport problem is resolved. So I've done the investigation. What happens now? Somewhere along the line, if the conduct is of the type of nature that we need to determine whether or not there's going to be discipline meted out, somewhere along the line there's going to be a hearing. It might be at the association level. I know the Junior Sharks have done this before. It might be at the league level. I know this has happened at NorCal. Or it might be at the affiliate, a full-blown hearing in front of the CAHA board, or its disciplinary hearing process. And it may involve implementing Bylaw 10. When you're responding to these abuse claims, you always have to follow USA Hockey's Bylaw 10. I'm going to go over that with you and very quickly, just so understand how it operates. I don't want to talk about it at length because it is somewhat intricate, and we have in this room CAHA's first vice president, who is become intimately familiar with it. He probably recite Bylaw 10 in his sleep at night, because he issues 2 or 3 letters every week explaining what this process is. There are people in our organization, myself, Tom, Steve, Laura, who, if you need to know about what Bylaw 10 is, or how it applies to a particular situation, ask. Follow USA Hockey's Bylaw 10, which is summary suspensions, hearings, and notifications. I'll go over that in a minute. And when in doubt about the process, ask. What I just said. In all cases, the disciplinary procedures and actions of USA Hockey and its affiliates and local programs shall be proportionate, reasonable, and applied fairly and equally. Makes sense. This is my name, email address, and phone number. Tom's is on the NorCal website and on the CAHA website, as is Steve's and Laura's as well. If you need to call us 24/7, we'll answer the phone. Jamie Campbell, this was done for our program down in Southern California, so I don't have Laura's name up here. She wouldn't give it to me, but anyway. This is Casey Jorgensen's phone number and email address. You should write that down. It's also available on the USA Hockey website. And this is Joyce's email and phone number. All of these people are waiting for your phone calls and are very helpful in resolving this. And we have these discussions amongst ourselves all the time. Bylaw 10. This PowerPoint has a lot of information in it. I'm going to go through it extremely fast so we can get to the hypotheticals, which are fun. But I want you to just pay attention to what the process is and understand that it's in place. And again, if you have questions about this as we go through this. A little bit of background. Who remembers Ted Stevens, the senator from Alaska? There was one thing good that he did, was he sponsored some legislation in the Congress entitled the Ted Stevens Olympic and Amateur Sports Act. This created the U.S. Olympic Committee, the USOC, and gave them a lot of powers in order to designate national governing bodies for the various different amateur sports that participate in the U.S. Olympics. USA Swimming, USA Gymnastics, USA Wrestling, USA fill in the blank. These are all national governing bodies, including USA Hockey, of the USOC. Well, the USOC, by designating who these governing bodies are, also tells us what we have to do. One of those conditions is that we're required to follow whatever they tell us to do. And one of those things is done through a USA Hockey affiliate agreement. We sign an agreement with USA Hockey and USA Hockey with the USOC that basically tells us how we're going to deal with their rules in the various different geographic areas. All right, I want to talk about how these rules protect us if they're followed properly. Most states have what's called generically private association laws. How many folks in here own or live in a condominium project? Wow, most of the people in Southern California did. But if you did live in one, these have their governance is dictated by statute. One of the things that their governance says, as long as volunteers on boards of directors, etc., don't act capriciously or maliciously, they're not capable of being held accountable in a court of law for the acts of the organization. We have that same type of relationship as a governing body. So if we follow the rules, courts will generally leave us alone. We can basically police ourselves and govern ourselves. Courts must defer to a voluntary organization's own interpretation of its rules, regulations, bylaws, etc., so long as they're not unreasonable or so long as they're not being interpreted to do something to somebody inappropriate. And courts won't review the results of our processes as long as we provide our members with a substantive and procedural due process. That means as long as our disciplinary procedures are fair, we don't have to, we can avoid having the courts step in and act differently. Again, as long as we do it with the right state of mind. When a party is suspended without being afforded the rights accorded to them in the bylaws, courts may intervene, overturn the suspension for failure to follow the bylaws, and perhaps even punish people that don't do it properly. So the purpose of Bylaw 10 is to deal with dispute resolutions, all claims, demands, discipline, or disputes that arise. And the purpose of it, as is stated in the bylaws, is so that we can bring these issues to finality and avoid court proceedings concerning them. Failure to follow the procedures that are set out in the Bylaw 10 may obviate that, however. Yes, sir?
Are the bylaws validated ahead of time or for being reasonable or not until there's
I understand. He wants to know if they're validated ahead of time. The answer to that's no, in the sense that we haven't asked a court to look at these and say if they're fair. And we're always subject to having to support that our bylaws were fair and impartial and were administrated properly. That's why we have a legal counsel, CIL, and we have a legal counsel, SEL, who spend a lot of time refining these rules. And I'm satisfied as a lawyer that they're as long as we follow them, we'll be just fine. Failing to follow them, however, might make a party who made a mistake, usually one that's malicious or capricious, personally liable for what that mistake entailed, at least from a cost and expense way. And that's one of the reasons it's important to follow the bylaws, and if you have any questions, ask, because typically somebody in this room is going to know. These rules subject a party to summary suspension or disqualification from membership. And that's another reason why we have to be very fair and impartial in the way we proceed and provide substantive and procedural due process to folks. Discipline means a suspension, probation, censure, or other discipline of a party. Administrative action is an action or decision by USA Hockey or its affiliates or local leagues or associations other than discipline that affects a party's eligibility to participate in domestic competition or to participate as a member in the organization. An administrative action may be hockey mom or hockey dad, you've misbehaved, we don't want you around, see ya, here's your hat, put your fez on the table, you're out of the lodge. Maybe like that. Typically, you can't suspend somebody from participating until and after there's been a hearing. Now, there's several exceptions to this. One of them is on the player side. If an adult player or a minor player decides that they're going to go after a referee and hurt them, physically abuse them in some way, they are automatically suspended at that point. I think match penalties, Tom, doesn't that do it also? Match penalties, and the problem with assaulting an official is that it's automatic 1-year suspension unless you can prove that it wasn't what the referee said it was. And this is happening more and more, and it's disturbing. But typically, you can't suspend somebody until after you've had that hearing. And this is where a SafeSport complaint might come in on something lesser than physical or sexual abuse. Probably shouldn't suspend them until that hearing takes place. I don't want to go through into the weeds on all this. Hearings are set at a certain time. Participants in the hearings, the accused and the people that make the complaints, are given an opportunity to present whatever evidence they have. They have to be set at a location close to where they live. In other words, if an event occurs in San Diego and Tom sets a disciplinary hearing at our duck lodge in Tule Lake, that's probably not fair. It has to be somewhere in Southern California. And we actually travel north and south when we have to conduct these disciplinary hearings. Many of them happen at our board meetings, which 5-6 times a year, mostly in Southern California, once in a while up here. And if an accused person is willing to waive the notice requirements and the location requirements, then we can do it. We get that in writing, and that takes place on a fairly regular basis. There has to be a hearing committee. Must be at least 3 impartial people, disinterested. And we have to offer that hearing within 30 days under most circumstances. The notice has to be sent out, has to be in writing, has to be done timely, and has to include in it all of your investigation, the statements and whatnot that we talked about earlier. If there is a suspension, it remains in effect until this hearing takes place. That's why it's important to follow these rules. Because if it doesn't take place in the right period of time, a suspension is over with before the hearing takes place, and it makes the hearing difficult. Location, talked about that already. Hearing requirements. Well, it has to be fair. Reasonable notice, proper provision of what's going to take place, what the evidence is. They have to understand what the consequences or adverse findings might be. And at some point, we can probably are going to prepare blanket letters that we send out to provide to you folks just on an information basis to show what's in these letters. However, we get them from USA Hockey, and they have all this stuff in it. You have to provide an accused person with a reasonable opportunity to present their case and argument. That means if they want to bring a lawyer with them, you have to suffer through that. And it's very interesting. We've had several instances in the last couple of years where lawyers have represented people at these hearings. As somebody who's familiar with the system, I kind of wonder if they're really helping them. But they're allowed to be there, they're allowed to make an argument, and they do. The appeal procedure must also be provided at the point in time where a decision is made. Every time we have a disciplinary hearing, Tom writes a letter to them with the outcome. And it says certain things. It says what the accusation was, what our findings of fact were, if you will. We confirm that you did violate this rule, and here's what's going to happen to you. And if you don't like this, you can appeal to USA Hockey. Remember that the burden of proof in all of these hearings is what we lawyers call a preponderance of the evidence. There has to be more evidence that that is presented that it's true than there isn't. In other words, it's not beyond a reasonable doubt to a moral certainty and all that stuff. It's a preponderance of the evidence. Is it more likely than not that this player two-handed somebody and then pummeled him on the ground when it was over with? The evidence says that it is. That's all it has to be, 51%. And again, hearing committees have to act within a reasonable period of time. I've already kind of covered this. You have to tell people what the scope of the decision is. And I learned something the other day that I wasn't aware of. I've been doing this for quite a while. The organization, as long as it has the ability to suspend somebody after a hearing in its bylaws, can do it. But its power to suspend only goes as far as that organization, if it's an affiliate, if it's a club, only as far as it reaches. And we typically tell people, we at CAHA are suspending you from all USA Hockey activities. Well, we are, but we probably can't do that unless we ask USA Hockey to comply with our decision, which they will do pending a hearing all the time. So but the point is, the USA Hockey has to approve a suspension or disciplinary matter that takes place in all of USA Hockey, or theoretically an adult player can walk out of California and go to Oregon and play in an adult game. I just learned that, so I thought it was kind of interesting. There are circumstances where suspensions take place prior to a hearing. This is very rare and it's disfavored. Those situations involve, well, playing rules, which under certain circumstances. But let's say that you're the SafeSport coordinator for Club XYZ. Somebody tells you that Coach A has been having improper relationships with a minor. You do your job, you call the cops, they come down and they arrest the guy, and the district attorney charges him with the crime. That's a situation where a summary suspension can and should be issued. When you do that, though, you have to tell this person, who's now out on bail, maybe has one of those really fancy new pieces of jewelry wrapped around his or her ankle, that they're entitled to a hearing within a very short period of time at which they can contest the summary suspension that USA Hockey or its affiliate has now meted out. Now, this guy or gal has criminal charges, serious criminal charges pending against him. Do you think, particularly if he's represented by a competent lawyer, that he's going to ask for that hearing? If he did, the prosecutor and probably the investigating officer would be sitting in the audience. In other words, in situations where there's a potential for self-incrimination, if a participant who has been suspended asks to suspend the hearing, we do that as a matter of course until after his criminal matter is over with. But they're entitled to it, and if they want it, they have to have it. That's the point of all of that. Kind of gone over most of this stuff. Appeals. Once we've acted and somebody exercises their right to appeal according to the properly written disciplinary letter that they received, USA Hockey will submit this to its disciplinary review executive committee. It's probably not the right name, but it's something like that, and they will hear their appeal. Interestingly enough, appeals in this context are done very similar to appeals in a civil action. We don't reinvent the wheel in front of USA Hockey. We as the affiliate send them what it is that we did and why we did it with all of the evidence, and the person who makes the complaint is entitled to put in paper whatever it is they want to put in there, which is I didn't do it. Those guys down there at Kaha are all full of it. They don't know what they're talking about. I never touched Johnny, whatever. The USA Hockey is going to look at everything to determine if the process under Bylaw 10 was applied and that it was fairly applied. Was there evidence that supports the actions taken by Kaha? Did they give them an appropriate opportunity to be heard? Did they tell them about their appellate rights properly? The answers to all those questions are yes. More likely than not, USA Hockey is going to uphold our decision, and that's over with. It's done at that point. We've suspended coaches in our organization for 2 years. The appeal to USA Hockey was confirmed because we dotted all the I's and crossed all the T's. We've had coaches who are participants, moms and dads, who did things inappropriate. We've suspended them, and our appeals have been upheld. I'm proud to say that we do a pretty good job at Kaha in getting this process done fairly and properly. People get an opportunity to be heard. In large part, we have Steve to thank and Tom to thank because it's a tough job. It takes a lot of time and a lot of typing.